Hey everyone, welcome. On behalf of the entire American Red Cross and our International Humanitarian Law program here at National Headquarters in Washington, D.C., welcome to another one of our national webinars. This is a really special webinar that I've been excited about for a while, and it's special not just because it's a great and very relevant topic, but the person delivering it is very special to our team. Sophia Lingar is our IHL fellow. She's going to tell you a little bit about her personal background, her educational background, her educational pursuits right now. But what really matters is she's emblematic of our program. She came to us as a volunteer with limited sort of training and experience in the IHL field. And over the past few months working with our team, she has really grown that knowledge, and she's poured a lot of hard work into preparing this webinar for all of you here today. So I'm really excited for all of you to see her hard work pay off. And without further ado, Sophia, I'm going to hand the mic off to you and enjoy everyone. Thank you.
Hello, everyone. My name's Sophia, and as Thomas mentioned, I am an intern with the American Red Cross IHL team. So I graduated with a bachelor's degree in political science in 2023, and I am now in my second year of a master's degree in international humanitarian action, which I'm doing through Uppsala University in Sweden. As a part of that second year of this program, I had the chance to do an internship this semester, which led me to this team. The topic we're going to be talking about today is the intersection of IHL and counterterrorism. So we are going to start with some definitions and general ideas of the topics before jumping into things such as the difference between IHL and counterterrorism and their overlapping areas and why those are important, as well as looking at how the two bodies of law kind of interact and somewhat protect civilians. And finally, we're going to end by spending a little bit of time looking at the humanitarian response. So, how counterterrorism measures and international humanitarian law interact with humanitarian action and some of the laws that are governing that and playing into that. So, to start, we're going to look at counterterrorism and international humanitarian law separately. And we will come back to international humanitarian law, but are going to start with counterterrorism, and more specifically by looking at terrorism to start. So there are many different definitions that states use domestically, and there's no standardized definition of terrorism internationally. However, there are some common elements that domestic and international definitions of terrorism tend to have. So these include the threat or use of violence by a collective group that may or may not be organized, some element of unpredictability, and the actions affect those who are not taking part in hostilities, such as civilians. The actions are carried out due to some sort of movement-based objective or motivation. So that could be political, ideological, racial, religious, anything that's motivating a group to do something. The group is often trying to compel a government or an international organization to do or to abstain from doing an action. The definitions also include an attempt to destabilize or destroy the political, constitutional, economic types of structures that a country has or that an international organization has. There's also an element of causing intimidation or a state of terror in the civilian population. And finally, whatever action is being carried out violates some sort of law. So that could be criminal law, international conventions, or other relevant laws. So, even though there's no universally agreed upon definition, there are some international definitions that are important because many organizations and states use them as the foundation for their own laws. So, the first of these is the UN General Assembly definition, which is actually taken from Article 2 of the 1990 International Convention for the Suppression of the Financing of Terrorism. And so this convention states that acts that are intended to cause death or serious bodily injury to a civilian or to any other person who is not taking direct part in hostilities in an armed conflict and that has the purpose to intimidate a population, to compel a government, um, in, to do or not to do something would be considered terrorism. So, two of the key parts of this definition that were in that list that I just laid out of common elements is that the actions affect those who are not taking part in hostilities, as well as that they cause intimidation and that they try to compel a group to do something. The UN High Commissioner for Human Rights also has no definition themselves, but they say that states should be guided by the key elements of acts of terrorism that are provided in Security Council Resolution 1566 from 2004. So these include attempting to compel governments or international organizations, as well as causing terror in the public or in groups of people by carrying out acts that cause serious bodily injury, death, things like that. I also wanted to include how the United States defines terrorism because I would assume that a lot of us here today are from the United States, making this relevant to us. So, the US actually defines terrorism in many places, but the one that's most often referenced and used can be found in US Code Title 18, Section 2331. So, in this, terrorism is defined as activities that involve violent acts or acts dangerous to human life that are a violation of the criminal laws of the United States or of other states, and that appear to be intended to intimidate or coerce a civilian population to influence the policy of a government by intimidation or to affect the conduct of a government by mass destruction, assassinations, kidnappings, anything like that. So, by looking at these three definitions, there are a lot of key elements that overlap. Um, and when combined, these common elements are kind of what to think of as we frame the later part of our conversation. So, involving intimidation, instilling fear, some sort of coercion, physical harm, and the violation of existing laws. So, now that we've looked at some of the common definitions of terrorism, we can look at what counterterrorism is. So, according to the United States, counterterrorism entails the efforts to combat foreign terrorist organizations or other individuals and entities that are engaged in terrorist activity or the support for such activities. So, a general way to look at counterterrorism is to view it as international and domestic instruments whose objective is preventing and suppressing acts of terrorism, as well as support for terrorism. So, we've now looked at terrorism and counterterrorism and the definitions that for those. So now we can look at international humanitarian law, or as it's also referred to, IHL. So the terms are interchangeable, so I'll probably use both throughout the rest, but same thing. So international humanitarian law, I'm not going to go super in depth here with the definition, but it's the body of law that governs armed conflict. So it lays out what can and cannot be done by states and non state armed groups that are party to an armed conflict. I wanted to lay out here some sources of international humanitarian law, like what governs it, before I start referencing those later on. So the first thing that I'm going to reference is Additional Protocols 1 and 2 to the 1949 Geneva Conventions. So the additional protocols came into effect in 1978, and Additional Protocol 1 applies to international armed conflicts, or IACs, and Additional Protocol 2 applies to non-international armed conflicts, or NIACs. I'll also make reference to customary law, so which is as it sounds, it is set on custom. So that means that the way that states have behaved in the past has become the expected way for all states to now act, with potential repercussions for breaking those rules, even if the state never signed on to any sort of agreement. Final part here concerning definitions that I wanted to lay out is that technically the term terrorist in situations of armed conflict has no associated special legal significance, and it's not defined within IHL. However, references are made to terrorism in some of the bodies of law that govern IHL. For example, in both Additional Protocol 1 and Additional Protocol 2, it stated that acts or threats of violence, the primary purpose of which is to spread terror among the civilian population, are prohibited. And Additional Protocol 2 also prohibits at any time and in any place acts of terrorism. So there's no definition of terrorism in that or counterterrorism, but reference is made. So now that I've laid out that foundation, we can look at some of the more interesting aspects of how these two bodies of law interact and how they differ from one another. So to start with here, we're going to look at the view of the cause of belligerence, or in other words, those who are engaged in hostilities, and how that differs between IHL and counterterrorism. Simply stated, IHL is not concerned with the legitimacy of any cause pursued by belligerents, whereas, by definition, counterterrorism is. And this is because IHL is there to make sure that all parties to an armed conflict have the same rights and obligations in the actions they carry out. This provides protection for those who have less power or who are not involved in the conflicts, such as civilians. And this is especially important because with the modern day abilities that can be used in armed conflict, IHL helps to provide something almost like a playbook of what can and cannot be done to protect both the earth and those who are living on it. It does not matter in IHL why people are fighting, as long as they are doing it following the guidelines and norms that have been established. In other terms, IHL applies independently of whether the acts that trigger its application are lawful. Counterterrorism, on the other hand, tries to limit and lessen terrorism. If we think back to those common elements of terrorism that I laid out at the start, terrorism is, by its nature, a term that is connected to groups having specific causes that they are carrying out their actions because of. For example, this might be coercing a government to finance arms shipments through the use of violence. So under counterterrorism laws, that difference in lawful versus unlawful doesn't exist. And this is important because it means that there is no legitimate target for a terrorist organization like there is in IHL. And this is because under IHL, acts of violence can be legal. All right, so I now want to take a quick pause from just talking at everyone, and I want to ask you a question. Can an organization that has been designated as terrorist be a party to an armed conflict? So I want you to think about it and to put your answer in the chat. So you can put a simple yes or no response, and then feel free after you can elaborate on why you think you might be right if you want. I'm going to give a little bit of time for everyone to put their answers in. All right, give it another 10 seconds. All right, so the answer here is yes. So this is because both states and non-state armed groups can be party to an armed conflict. So if you had a non-state armed group that was labeled as a terrorist group, fighting with a state, for example, the same criteria would need to be met as compared to if they were not labeled as a terrorist group in order for a non-international armed conflict to be taking place, which this would be because you'd have a non-state armed group in a state. So you need two things here. You would need, first of all, a minimum level of intensity in the fighting between the group and the state, as well as the group would need to be sufficiently organized. So if this threshold is met, then a designated terrorist group is engaged in a non-international armed conflict. Therefore, who the groups are that are taking part in the armed conflict does not matter. It matters, to the extent of classifying the conflict as an international armed conflict or a non-international armed conflict, because there's slight differences in what's protected under each. But beyond that, IHL will apply regardless, meaning that a group that is labeled as a terrorist group, can be party to an armed conflict. So now, why did this matter? And so it matters because it brings up the question of how this would actually work. So if acts are legal under IHL and not counterterrorism laws, or vice versa, it could be either way, how would that work? Or what if the acts are illegal under both types of law? Then which would take precedence? So the short, easy answer is that both of the two types of law would be applicable. There would be a dual legal character in which both counterterrorism and IHL could apply. This type of scenario where two types of law overlap does not exist only with IHL and counterterrorism. For example, there can be this type of overlap often between human rights law and international humanitarian law. But when both types of law are applicable, typically whichever is stronger and more specific to the situation would take precedence. The question here is which type of law, IHL or counterterrorism, is more specific and narrowly defined? The answer is that there seems to be debate on this. So if you look at the way different states or entities have acted, the United Kingdom, for example, does not criminalize acts of violence as terrorist if they are carried out in non-international armed conflicts. However, you then have the Court of Justice of the EU, which in a 2014 case decided that IHL being applicable in an armed conflict does not imply that legislation on terrorism does not apply in those same acts. Therefore, there is a potential for issues to arise when acts are legal under IHL but not under counterterrorism laws. And this is because if IHL is not considered to take priority, there's a potential that some of the deterrence factors that the existence of IHL brings could be limited. If actions that are legal under IHL are unlawful because a party to an armed conflict is labeled as a terrorist organization, then it can discourage IHL compliance because there's essentially no incentive to follow that body of law. So now, using that, we can kind of look at civilians and how these two different bodies of law interact or protect civilians. So civilians' needs, such as food and medical aid, must be provided at all times. During armed conflict, these needs must still be met, with primary responsibility falling on the controlling party of the territory. Additional protocols 1 and 2 protect those who provide medical assistance both from attack and from prosecution when providing aid. However, for humanitarian personnel, while Additional Protocol 1 does state that those carrying out relief operations must be respected and protected, there's no direct protections as strong as for medical personnel. These protections can be inferred, however, from several established IHL rules, including the prohibition on starvation and that the wounded and sick must be collected and cared for. It is also important to note that it does not matter what type of state or group is in control of a territory. Relief operations exist to benefit civilians, and this does not change if it is a group identified to be terrorist with control. Such a group being in charge also does not create a valid reason for withholding consent for relief operations. All right, so now that we've looked at all of that, we can start to look at the humanitarian response and how counterterrorism can affect that. So, when an armed conflict is taking place, either with a terrorist organization as a party to the conflict, or if it's just existing in the region where aid needs to be delivered, it is highly likely that humanitarian workers will come into contact with terrorist organizations, either directly or indirectly. For example, a non state armed group, including those that are labeled as terrorists, are often directly tied into the society in which they have control. There are many ways in which this can be the case, such as financially, by that organization providing medical assistance, or by them being in control of roads or checkpoints. The issue with this is that in many international, regional, and domestic counterterrorism laws, there is a prohibition against supplying terrorists with material support, services, or any type of assistance, as well as even being in association with a terrorist organization. And this has the potential to criminalize humanitarian organizations and their personnel for the work they do, especially because these rules apply when these types of services are supplied directly or indirectly. This means that things such as the payment of utilities, the provision of supplies such as medicines and tools, the improvement of infrastructure such as homes, or even just large scale food assistance can ultimately be within the scope of these types of prohibitions. However, there are ways around this, which we are going to look a little bit at. So, one of the major documents that governs counterterrorism, in which some of these concerns come up, is the 1999 International Convention for the Suppression of the Financing of Terrorism. So, this convention has this type of prohibition in the supplying of funds, in that if a group that is labeled as terrorist has the potential to be able to use them in order to carry out an act of terrorism, then that's not allowed. However, there are safeguards, which is kind of how we can bridge that divide and find a way to protect what IHL governs within counterterrorism law. So, this convention, for example, requires that there is intention or knowledge that the funds would be used for the commission of an act of terrorism, as well as a statement in the convention that it does not affect the purposes of various types of international law, including explicitly international humanitarian law. The worry is that there is still a continued push to make certain counterterrorism laws stricter. The Financial Action Task Force, or FATF, is an intergovernmental body representing most of the world's major financial centers. And one of the things they do is they provide recommendations for combating the financing of terrorists. In Article 5 of their 2012 recommendation on international standards on combating money laundering and the financing of terrorism and proliferation, which is a mouthful. They state that countries should criminalize not only the financing of terrorist acts, but also the financing of terrorist organizations and individual terrorists, even in the absence of a link to a specific terrorist act. And this was updated in 2023, this recommendation, in which this wording was kept the same. So the reason for why this funding guideline should be stricter is based on this theory of fungibility. So this is the idea that organizations often spend available assets on activities other than those for which they were originally intended. This means that even if specific funds or assets that were acquired from humanitarian initiatives are used for legal activities, by having those, it frees up resources so that a group that is labeled as terrorist can now conduct more illegal activities than they could have before. This could mean that the funds or services that a terrorist organization obtained from humanitarians might not be used for terrorist purposes, but it makes it so that the organization can use funds that were previously earmarked for peaceful purposes on terrorist activities. So, the Financial Action Task Force's suggestion ultimately resulted in a binding UN Security Council resolution in 2019, so number 2462. And this made stricter guidelines around the provision of funds or other assets, pretty much in line with the suggestions from the Financial Action Task Force. However, the resolution included reference to international law and IHL and the need for counterterrorism laws to respect it, which helps to create a bit of a safeguard here. So, counterterrorism laws, international humanitarian law, it doesn't just happen at the international level, but at the domestic level as well. So, this also means that laws governing counterterrorism that interact with IHL do not only exist at the international level, but again, at that domestic level. So some domestic counterterrorism laws also include safeguards and exclusion clauses in their laws that protect humanitarian workers and allow for them to interact with designated terrorist groups to varying degrees. So Australia, for example, was the first country to include exemptions for humanitarian action for some of the crimes in their criminal code. So, associating with a terrorist organization, for example, is protected for a humanitarian purpose in Australian law. Other countries vary. So, in 2020, for example, the Republic of Chad created a law on the repression of acts of terrorism. And this has a clause specifically excluding humanitarian activities from its scope. The Philippines, in their 2020 Anti-Terrorism Act, have an exception for providing material support to terrorists when it comes to humanitarian activities. However, only certain actors are protected by this, and they have a council that decides if an organization fits the established criteria that the country has established. Switzerland, after much debate, created humanitarian exemptions to their amended penal code that made support for the activities of terrorist organizations illegal. Humanitarian organizations, however, due to this exemption, do not have to abide by the same strict rules. And actually, their first draft of this did not include the exemptions, and support for it was varied. For example, the Swiss Ministry, the Federal Department of Foreign Affairs, supported the safeguards, whereas their Federal Department of Justice and Police opposed having it. So here, overall, these types of exclusionary clauses are much more common in international counterterrorism laws as compared to domestic ones, but as these four countries show, there is precedence for them existing. So additionally, sanctions are another thing that can have adverse effects on humanitarian action. Counterterrorism sanctions tend to include things, excuse me, sorry, such as travel bans, financial sanctions, limits on the imports of goods, as well as some other things that have less an effect on humanitarian action, such as prohibitions on transfer of weapons. But sanctions can make humanitarian work more difficult because they create a spiral of effects, including making it difficult to obtain money from banks due to a fear of being held in violation of sanctions that are in place, as they could be considered to have indirectly supplied funds to terrorist groups. Often, donor clauses make it essentially impossible to work in areas where there is a potential to come into contact with organizations that are labeled to be terrorist. Some even ask for information in order to ensure that there is no contact with terrorist organizations, and this risks the impartiality and neutrality of humanitarian organizations. In addition, because sanctions regimes tend to restrict the imports of goods, delays or potentially blockages in supplies that are needed to carry out humanitarian activities from reaching those in need can occur. A wall is essentially put up between the work that humanitarian organizations need to carry out and what is possible due to sanctions. Since 2000, only two UN sanctions regimes out of the 14 currently in force that target terrorist organizations include explicit, legally binding humanitarian exemptions. So these are the Taliban sanctions regime that began in December 2000 and banned flights to or from Taliban controlled areas, and the Somalia sanctions regime from 2010 in relation to Al Shabaab, which related to financial components of aid. So, in the end, here, without strong exclusionary clauses in place at the international, regional, and domestic level of counterterrorism laws, limitations are placed on humanitarian organizations and on their ability to access communities in need. So, as we come to an end, I wanted to include this quote from the UN Office of Drugs and Crime because I thought that it encompassed everything that I talked about well. So, they stated that full respect for IHL in counterterrorism activities is a positive contribution to ending terrorism, a key objective of which is to erode the rule of law. And a final fun exercise, well, I don't know if I'd call it a fun exercise, but a final exercise slash suggestion is that you start to pay attention to how often you hear the term terrorism thrown around and whether or not the way it is often being used actually matches up with those definitions that I pointed out at the beginning. It's something that I started to do a few months ago, and I was surprised to realize how often the word is used in the news, in politics, in movies and TV shows, and just by the people in your day to day life. And often, what I noticed is that the term was not being used correctly, which I think is important because the term terrorism has the potential to have very divisive effects if it's being thrown around improperly. And so I now want to see if we have any questions. So please feel free to put those in the chat or the Q&A function, and I would be happy to answer them.
Thanks, Sophia. I first want to congratulate you on a job exceptionally well done. You picked a topic that is far from easy. I was surprised when you decided to dive into this topic because it's a relative um, fire swamp of information. And so if those in attendance still could give her a virtual round of applause, you can use the little emoji feature. I'm really proud of you, Sophia, all the work that you put into this webinar, the research, the prep on the slides, the practice sessions really showed in your presentation. Thank you for all that.
Thanks.
I had a question myself before, and we do have several questions that we'll get to in a second. But I'm curious, as you were prepping for this, as you were doing your research, what did you personally find sort of most interesting or most surprising as you prepped for this and learned about the topic?
Well, I think one of the first things when I started doing research on the topic that I started to have questions about was the way that the two bodies of laws interact. So, like when I was talking about how, like, what happens if both international humanitarian law and counterterrorism apply, I was super curious to find out what happens. So getting to research into that was definitely what most interested me in the topic.
Absolutely. And the questions predominantly in a lot of the chat focused on the designation or the defining of a terrorist organization, who gets to make the designation, that sort of thing. In your view from your research, is there a rule or a rule of thumb, even a custom, a practice for whose designation prevails if, say, there are competing designations, maybe one government designates a group a terrorist organization, the group itself maybe says that they are something else. How does that sort of thing work?
Yeah, so the first thing there that I found in my research, I listened to this really interesting panel discussion of counterterrorism experts, and they were talking about how a group that's labeled as terrorist is never going to view themselves as a terrorist organization. That it's incredibly rare, if ever, that somebody's actually going to label themselves as that. Um, but then the question comes up then, so as you said, what happens when there's different states or international organizations that are labeling differently? I didn't look super far into this. It's a great question. So if somebody, I don't know if somebody asked if this is your own, but I would love to look at this more if you wanted to reach out. But from my understanding, kind of with a lot of things, it would be whoever is kind of engaged in that position. But I'm not 100% sure on that answer.
Yeah. When you brought up the Taliban, and that's a really interesting example where that has gotten thrown into really sharp relief within the last 3 to 4 years. They remain, as you said, a designated global terrorist group, an SDGT, specially designated global terrorist group under an executive order from the United States, obviously. Yet they govern Afghanistan right now. And that's a fascinating dichotomy that has real world implications in terms of disaster response, humanitarian aid flow. So your presentation here is really timely. Is it up to a government to drop the designation? I mean, is the government that decides also the one that gets to drop it, or do sort of facts on the ground prevail? Can an organization reform and sort of automatically not meet the definition anymore? Any sense of that?
Yes, so they can. So if a state labels an organization, or they could also label a different state to be a terrorist organization, they also have the right and the ability to retract that and to no longer designate them as that. Typically, as you said, like the facts on the ground are going to come into play. Um, Potentially, even like international pressure could come into play there of why you might switch the designation there.
Absolutely. Uh, that's a classic lawyer answer that you're even though you haven't gone to law school, you're already ahead of the curve. You could probably pass the bar. It depends is is the phrase that I think we most use, but I appreciate it. Ashley, Christian, from my team, any questions from either of you? I know we answered everything, it looks like, in the Q&A box, but wanted to see if you wanted to put anything to Sophia.
I have a question, Sophia. Could you tell us what you found most interesting about your research on this topic and what you think might surprise someone?
Yeah, so I'll kind of answer that as two separate questions, I guess. So the first one kind of ties back to what I'd responded to Thomas's first question with. It was really looking at what happens when laws overlap. I didn't have a lot of experience looking at that. In school, I'd learned a little about how human rights law and international humanitarian law often overlap, but we didn't really dive into what then happens if they are. Um, so I was really curious to see how that would come into play when you're looking at international humanitarian law and counterterrorism. And then to the second part of what I found most surprising, I think that comes back to that final suggestion I gave at the end, is that when I started doing research for this, I started to pay attention to how often I heard the term terrorist, and then also how often counterterrorism and also international humanitarian law. Definitely heard didn't hear counterterrorism that much. International humanitarian law, every now and then I did hear it thrown around, or in especially news, when reading about different armed conflicts that are going on. But the amount that I heard terrorism, probably at least multiple times a week, I think that was most surprising to me, is I'd never paid attention to that.
That's really fascinating. And I think your perspective is really keen because uh, you have grown up obviously in the post 9/11 world, like your entire life has been in the post 9/11 universe, so to speak. And a significant chunk of that was impacted by exactly what you're saying. This business of designating terrorist groups and whatnot was at the center of the congressional act that led to or opened the door to a lot of U.S. operations in Iraq, Afghanistan, et cetera. The AUMF, the Authorization for the Use of Military Force, and you saw in that decade plus of conflict how the law can be stretched and brought beyond maybe the original intent there in the wake of or in the immediate aftermath of that legitimate terrorist attack on 9/11. So
Yeah.
that's really fascinating.
Yeah. I mean, I was born 3 months after 9/11, so I didn't exist to any
Yeah.
previous way the world worked. But I guess kind of tying also to Ashley's question, something else I found really interesting, as you were saying, how the United States started passing all these laws, and they had all this stuff going on. I kind of only knew about the US's side, but when looking into it, I found that Australia actually passed more laws domestically governing terrorism in the decade after 9/11 than the United States did, which I did not expect.
That's fascinating. And what's your sense? Are there instances that you've seen where the designation has gotten in the way of legitimate maybe humanitarian acts that the country itself is trying to carry out? So say a disaster happens and aid efforts are hampered. Did you see anything or come across any situations like that where the government almost gets in its own way using the designation?
I did not. I didn't see anything about that in my research. Doesn't mean it hasn't happened. But it wasn't included in anything I was looking at.
Sure. Absolutely. Well, and I think the modern one or the most immediate one that comes to mind would be that big earthquake that happened not too long ago in Afghanistan, and obviously a substantial amount of destruction and damage, and there were reverberations from that existing terrorist designation for the Taliban, what aid can flow in, what do sanctions allow or not allow, sanctions being their own sort of weapon in a way, have real world impact in a situation that has nothing to do with armed conflict, and folks are in desperate need of help, and how do you navigate around that legal construct? So, well, Sophia, thank you so much for all the hard work that went into this. You're an absolute pro. We're so fortunate to have you on our team. I'm glad this isn't the last thing that you're doing. It makes me very happy that we get to keep working with you and keep calling you a teammate. But thank you for this outstanding presentation, and I'll leave it to you to close it out.
Yeah, I also want to thank you for the opportunity for letting me do this. It's been a really cool experience to get to learn about the research that goes into something like that. And I also want to thank everyone who came, participated. So thank you.